constitutional activism that's characterized your life for the past 21 years. One thing you were talking about, the family courts, a lot of men come out of family court cursing the system. Recently, the Supreme Court of Massachusetts sent lawyers a questionnaire asking us about gender bias in the courts and basically oriented towards the rights of women. But a lot of men, as we know, come out of family court and they feel there's gender bias towards them. Now, can the federal courts help them?
Yes, because an important provision of the 14th Amendment is this: no person shall be denied the equal protection of the law in the defense of his or her life, liberty, or property. The liberty to be with his children's liberty to be with them, and his property rights as far as fair shares of support. One of my most famous cases, one that was featured on 60 Minutes, was when the Massachusetts Appeals Court accepted the brief of my client. I helped him with it, but very little, where he argued successfully that both the ex-wife and the father owe a duty of support. The family court judge had arrogantly just overruled the equal protection that follows with the Constitution when he says, as far as I'm concerned, only the father owes a duty of support. And so I told my client, I was sitting beside him at the counsel table, I said, we'll appeal that. And we did, and in 4 months, the Appeals Court of Massachusetts ruled in Sylvia versus Sylvia, 400 Northeast, second 1330. That's a shorthand way of referring to the law book, ruled that both the ex-wife and the father owe a duty of support. It isn't all on the father. This, of course, is in the best interest of the children because both parents should contribute to the support of the children. And the Constitution says, we got it.
The same 14th Amendment that was used to enforce voting rights in the South is the same 14th Amendment, of course, that you use to enforce men's rights in the family court system.
The equal protection of the law provides that the women, as well as the men, owe a duty of support to their children. And men should have an equal opportunity to apply for custody. Most of the time, custody goes to the woman. I've been asked, I was asked by a reporter for the National Enquirer, believe it or not, she said to me, well, you know, so many men dislike divorce courts, they feel cheated. Why is that? I said, well, really, isn't it true that most fathers love their children? Why, yes. And isn't it true that most fathers, 92% of them, lose custody of their children in divorce courts? And she said, yes. Well, put those two facts together. The fathers love their children, and they not only lose custody, but they lose contact with their children. This hurts. They are no longer accepted as a parent. They become a visitor. That's why they use that word visitation. And in nature, you can't convert a parent to a visitor. A parent is always a parent. And most fathers love their children. And most fathers lose not only custody, but actual contact and support of and helpfulness and direction and leadership of their children. And they need it.
Well, you refer to the fact that you have clients and you are not an attorney. We could get that point very clear. You're not a lawyer. You don't particularly care for the legal profession. You call our profession a monopoly. And
I say that lawyer, I say lawyer is a 6-letter dirty word. The present company accepts it, of course.
Thank you. But now, what are the rights of people to go on their own without a lawyer in court and to have coaches such as yourself by their side?
They have the absolute right to represent themselves because the 5th Amendment Due Process Clause and the 14th Amendment Due Process Clause provide and include counsel of one's choice. You can choose to be your own counsel. It's very, very important. I'll repeat that. One can choose to be his or her own counsel. Now, in addition, there are several people, such as myself. I'm a constitutional consultant, incidentally. And when people can't find honest, competent, diligent lawyers they can afford, then they have to go pro se or find a person who can help them. And when the Fifth Amendment was written and provided that due process includes the right to counsel, the word counsel meant not a lawyer, but a person learned in the law. And judges, both state and federal, have recognized that I am learned in the law, although I've never been to law school, and I've given talks, speeches in
Literally
law
hundreds
classes,
of seminars, too.
and in hundreds of seminars. The thing of it is that I am, without bragging, there's a fact that I am learned in the law, and in the 18th century, late 18th century, when the Fifth Amendment was written, counsel meant a person learned in the law. Therefore, any person, to summarize, can be his own lawyer. He has an absolute right, despite what lawyers say. Some lawyers say, no, you can't represent yourself in court. That's against the law. But the person also has a right to choose as counsel a person learned in the law. So you can represent yourself, or you can find someone like me.